All right, good afternoon and welcome everybody. We appreciate you joining us today, and we're excited to give you kind of our mid-year update on a variety of issues that are very important to you as plan sponsors, as plan fiduciaries, and they certainly are very important to our team of attorneys here at QPA. So as always today, you're going to get to hear from each member of our team. We're going to start our comments with Scott Liggett. We'll then transition into hearing from Chuck Smith, and then Mike Smoots and I will add some additional commentary on some follow-up topics. And here's really where we plan to go with our conversation today. We want to start with something that's not necessarily a legal requirement, but something that has become more and more important to those proactive, vigilant fiduciaries who are thinking deeply about making good decisions for their employees and for their participants. And Scott Liggett's going to talk with us about this growing importance of decumulation. Then Chuck Smith is going to walk us through a number of changes relating to Form 5500s and actually bring to you good news from the government. So we're looking forward to hearing from Chuck on those developments. Mike Smoots is going to move away from good news and talk about what happens when plan loans aren't handled quite correctly. Then we'll talk a little bit about a game plan for you over the rest of the quarter. In response to Secure Act 2.0. We'll wrap with some litigation conversations, and we're going to go around the horn and share with you these other issues that are really kind of top of mind for us as we look out over the course of the rest of the year. So, as I mentioned, we're going to start with Scott Liggett. And Scott, you've been doing this for a long time, and I know that you even have a background working with defined benefit plans or pension plans. And of course, when you do that work, the plan design really takes care of that notion of retirement income, the idea that somebody has the opportunity to be cared for after they retire. But now we spend all this time with 401k plans, 403b plans, and we focus on what? Getting people enrolled, saving at higher rates, and watching that account balance grow. We focus on accumulation. But it seems like we probably haven't spent enough time on decumulation. I know this is something that's kind of a point of passion for you. So can you kind of talk us through what you think plan sponsors ought to be doing in that regard?
Well, thank you, Matthew, and hello, everybody. There's a lot of focus and attention, as Matthew said now, on upcoming transitions for retirement plan participants to move from decades of saving money to starting to focus on decumulation, and that's the media term that gets used a lot, and sometimes it seems like an overly technical term, but in short, decumulation is converting all those years of retirement plan savings into a plan, an approach for income in retirement. And so a retirement plan sponsor really should focus time and attention to helping plan for those sorts of transitions for their employees, for their participants. And there's a number of reasons. And I've set out a few that I think are important. First and foremost, more and more participants are trending to leaving those hard-earned savings in the retirement plan, because you plan sponsors have done a great job of providing a low-cost, efficient mechanism for them to save. And they also have the fiduciary oversight of their monies while it's in the retirement plan. So more and more, particularly larger account balances, I believe are going to continue to keep their money in the plan. And so those participants, as they transition into retirement, are going to be with you longer through that sort of relationship. As you're going to hear more, and you've heard us talk briefly in the past, this Secure Act 2.0 has eliminated a lot of the barriers as far as having annuities in your retirement plan. So we're going to talk a little bit more about that and the need to become more and more familiar with what those new options are. Similarly, I think that we're going to see, even an accelerated rate of Roth monies in 401k plans, 403b plans accumulate. I think we're going to have an acceleration there, partly due to catch-up contributions at some point in time. For certain higher income workers are going to have to be Roth monies, as well as the potential for employer matches to be made as Roth dollars. And those Roth dollars, now it's been clarified in your retirement plan, they're not subject to RMD distribution. So I think money is going to stay longer in the plan for all the right reasons. And, as Matthew said, retirement plan sponsors strive to stay abreast of what's going on and to continue to improve and learn more about what's out there and how to best help their people. So I think those are just some key areas to think about. So now, what should you all be doing? What should a plan sponsor be doing? This slide, I kind of lay out some kind of simple, straightforward approaches that you can do today, and you can begin doing today. And you need to look at your current plan structure, because demographics shift for a lot of organizations over time. And you need to take a look and see if your investment lineup currently offers the right investment options for someone that is nearing or in retirement. Bring in your retirement plan advisor and maybe get a second look or a new look at whether you're providing the options that are best for your people. Also, a very simple approach, kind of a basic step, would be making sure that your plan allows for systematic or installment distributions. The idea of taking $1,000 out a month to pay bills in retirement, whatever the case may be. And sometimes people are surprised that older plan documents still limit a participant's options to be basically all or nothing. They can choose, once they've terminated or retired. A lot of plan documents still limit it to, well, you have to take the entire balance or leave it all in. And you want to make sure, I suggest, making sure that you have that option for your participants to take out systematic withdrawals. And be looking at that, because different vendors, different record keepers have different approaches to this. And I think it's important, if you currently offer it, or if you're going to offer it, make sure there's no fees, particularly for electronic withdrawals. So that's something you can do in the near term. And then you can also, revisit whether participants are getting adequate help with, calculating their income in retirement. What are they going to need? Plan for what they're going to need in retirement. And so you want to evaluate your record keepers' online tools. There's been a lot of developments in technology over the last few years. Record keepers have made great strides here. So you want to evaluate what your record keeper can offer, and then is your advisor offering targeted education for those nearing retirement age? I threw in some statistics there about how a majority of people guess at their, what they're going to need in retirement. What are they going to spend in retirement? So you want to make sure, or at least strive to have opportunities for your participants to get some help in that area. And your retirement plan advisor should be helping you do that, because still a number one worry for individuals is running out of money. So I think again, this slide I wanted to just cover kind of what you can be doing today in the near term. And on the next slide is more of the keeping abreast of what's going on. There's a lot of new products out there, and whether it be income in retirement, annuities in retirement plans, and various different approaches, various different programs and products. And I've listed out a few here, and one that I'm seeing a lot of development in the last few years, and it's only going to get more so, is taking the approach of target date funds, which most people are familiar with, and managed accounts, people are familiar with, a lot of retirements are, and really marrying those two together, or merging those two together to have that accumulation phase in the first part through the target date early in their career, and then at a particular age, then helping them transition to more of a personalized managed account approach, which can factor in their retirement income goals, what they need for retirement. Technology, again, has caused a lot of advancements here. And so you want to, get an understanding, what does your record keeper provide, what else is out there, and have your advisor help you with that. Guaranteed income products. When the market's going up, rising tide floats all boats. Then when we have volatility, like we had last year, and we've had during COVID, and volatility is here to stay. A lot of times people focus on, well, I'd like some degree of guarantee much like the pension, the old time defined benefit pension plan approach. And so you're going to see a lot of discussion and topics about guaranteed income products. And so you'll want to become more familiar with what that means and what that looks like. And then you want to consider, what does that guarantee, who's providing that guarantee and how is it calculated? Same way in plan annuities, I mentioned before, the Secure Act has allowed more availability now, and that's going to continue to develop. So you want to become more comfortable and confident with that as well. And regardless of any of these types of approaches, when you're considering new options for your retirement plan, you want to focus on the simplicity and ease of understanding for the participants. What's the cost going to be? Is it portable if the person leaves or if you change record keepers? And then what is the level of support and educational resources for the plan sponsor and participants? So again, I think, as Matthew said, this is not a legal requirement, but I think more and more as retirement plans continue to grow in assets and as the demographics change of your longtime employees, they're going to want as much help planning for that retirement and that retirement phase of their lives as you've done for decades, helping them save for that retirement.
Yeah, I appreciate that perspective, Scott. I think probably what we're likely to see is over the next 5 years, each year we'll likely see an exponential increase in the number of solutions available on your plans. You'll find out that record keepers initially will have one option for you, and then it'll be 2, and then it'll be 4, and then it'll be 5. I think there will be more options in a few years, and frankly, some right now find that there are not enough of those vehicles currently available. But what you highlighted for us is there needs to be a conversation to get this going. And frankly, I would love for committees, or if anybody's taking notes, to really write down the idea, hey, we spend all this time on accumulation. Have we given any thought to decumulation? Have we given any thought to how we're going to help people ensure that they can make their money last? So Scott, appreciate your perspective on that. And we're going to pivot over to Chuck, and I promised good news from Chuck. We certainly are in an environment where things seem like they become more and more challenging. And Mike and I are going to talk later about kind of additional requirements and frankly options, but the strings that come along with those options. But the question really might be, is there anything that the government has done recently that's going to provide some relief, perhaps to make it a little bit easier on plan sponsors? And Chuck, I know you've got a topic to talk about today that illustrates that type of help from the government.
Yeah, Matthew, thank you. And the short answer is there is some relief provided for them from the government with respect to administrating retirement plans, especially in light of the Secure Act 1.0 and 2.0, and that relates to the Form 5500. So all of you in the retirement plan space are probably very familiar with your Form 5500. It's your annual report. It's really an informational report that you file, and it's prepared by the IRS and the Department of Labor, as well as the PBGC. And what you might not know is each year they update this form. Frankly, it's a bit of a yawner as far as regulatory updates come. Truth be told, back in my record keeping days, I would look at it, make sure our processes and procedures were up to date, to take into account those very small changes that would be made on an annual basis. But this year's a little bit different. There were significant changes to the Form 5500 rules. And Matthew talked about these a little bit at one of the ERISA, or the fiduciary 15s. But I just want to take a little bit broader approach to what those changes are, explain them in more detail, and maybe provide a couple of takeaway items that you can use today to try to maybe simplify the administration of your plan. So what was the change? It's right there on the top, the new participant count rules. Historically, when you're filing your Form 5500, you use the number of participants in your plan as of January 1, but this included everyone who was eligible plus everyone who was terminated with an account balance. This is, while it seems easy on its face to count, it actually did create some difficulties. It's not that simple. You've got eligible employees with no account balance. You've got to include them. What if you've changed your classifications and someone has an account balance but is no longer eligible? So it's more difficult than that. And it was somewhat unfair. Plans with employers with a lot of employees, but maybe not all of them participating, would be in the same boat as a smaller plan. So I would actually have to file, a larger company with not a lot of participation would still have to file a large Form 5500, which is for anyone over 100 participants. So even though two separate plans could both have 40 account balances, one of them may be filing a large plan audit, a large plan Form 5500, while the other is a small plan audit. So this change, this Form 5500 change, the new form, only counts now those with account balances as of January 1st or the first date of the plan year for plan years beginning on or after January 1st, 2023. So for most plans that operate on a calendar year, these new changes will take effect for the Form 5500 that for 2023 that you will file in 2024. So what's the impact? I referenced the small plan versus large Form 5500 or small plan Form 5500. And really, the form that plans with over 100 participants file is much more extensive. Instead of just being a couple pages, it's numerous attachments, much more difficult to complete. And with that comes the requirement to do an audit. For those of you that have gone through an audit, or you go through that annual audit, it's an extensive review of your plan by an accountant. And the cost, I was reading in the proposed regs and in the final regs actually, and they were talking about it's somewhere to $1,000 to $10,000, and I don't see anyone who's paying that little for an audit. It's typically between $10,000 and $20,000. So this will provide a great amount of relief for those plans that previously were over that 100-person limit, but now will be under the 100-participant limit and will no longer need to do an audit. The DOL expects this change to affect about 20,000 retirement plans. So quite a bit of significant savings there. And the reason behind all this, well, one of the main reasons was because of the part-time inclusion, the inclusion of part-time long-term employees. We talked about this at an ERISA attorney talk a couple sessions ago, where anyone who works between 500 hours and 1,000 hours for 3 years in a row, and now with Secured Act 2.0, it's going to be 2 years in a row, will need to enter the plan. And so that's going to increase the number of participants. And so this was a way for the government to ease that burden. But actually, it has far more reaching ramifications. It's not just going to be the plans with small or with short-term, long-term, long-term, part-time employees, but it's going to affect a lot of other plans. So the basic rule is if you have over 100 participants, you have to file a long form. If you have less than 100 participants, you should do the short form. But I wanted to throw in this 80-120 rule. So basically what that says is that besides the general, if you are between 80 and 120 employees or participants, you have the option of filing the same form that you did last year. So the effect of this is that if you're a small plan, even if you cross over 100 participants, you can continue to file that small plan form until you actually reach 120. And then once you're over 120, you're going to have to continue to file that large plan form, the long form, and your audit until you drop back down under 100 participants. So there's sometimes some confusion about what the 80-120 rule is and how it marries with the general rule of 100 participants. But just remember, on your way up, 120 is the limit, and on your way back down, you've got to go back under 100 before you can use the short form for small plans once again. So what are some steps that you can take this year? Well, review the participant count as of 1/1/2023. That's going to impact what form you file for this year. You can't change that number, but at least be aware of what it is, and it's probably going to be different than what your ending balance was on 12/23 or 12/31/2022, because now you're going to have a different counting formula. But that'll prepare you for whether or not you're going to have to do an audit with the large plan form next year. The second thing you can do this year is try to prepare for next year's Form 5500 by reducing the number of participants that you have in your plan, specifically terminated participants. Those count they counted before, they're going to continue to count, but now you may be a lot closer to that 100 participant limit. So try to eliminate them out of your plan. If they have under $5,000, you can force them out, send them a letter, and then within 30 to 90 days, you just move them out of the plan, either to an IRA or in cash. And the second thing you can do for those individuals is send them a reminder letter. There's nothing prohibiting you from reminding participants that they have an account balance. It may be, it's going to be over $5,000, but maybe it's $7,000, $10,000, and just give them the forms, direct them where to go to take a distribution from the plan. So maybe you can reduce the number of participants to get under that 100 participant limit. And then the final thing is to consider these audit requirements and future plan design and administration discussions. I don't think this is going to drive those discussions, but it's just something to have in the back of your mind. And one is automatic enrollment. We love automatic enrollment. The government loves automatic enrollment. But one side effect of that is it will increase the number of participants in your plan and may push a plan over the limit, the 100, 120 participants. So just think about that when you're implementing automatic enrollment. Again, I don't think that should necessarily stop you, just something to weigh. And then the other one is the use of a match or a profit sharing contribution for your employer contribution. If you use a profit sharing contribution, everyone who's eligible is going to get an amount for that year, and they're going to have an account balance and be included in the 5,500 count. Versus if it's a match, anyone who doesn't participate would not receive that match, and therefore they may have a zero account balance, would not count towards your 5,500 count. So those are a couple things. There's also contribution timing. If you have a choice between doing it at the end of the year or at the beginning of next year, perhaps you want to hold off until the beginning of next year to do your employer contribution, just so that as of 1/1, your participant count is a little bit lower. And then finally, ADP test corrections. You have all year to make those corrections. Maybe you want to do it sooner rather than later. So if someone gets a correction, they can remove it from the plan if they're a terminated employee especially, and not dump it in there on 12/30 and have it roll over into the next year.
Yeah. So Chuck described that annual 5,500 update as a bit of a yawner, but I remember the day when the government put out this new guidance. Here we are trying to sift through all these Secure 2.0 changes, and Chuck ran into my office and he said, did you see this guidance? It was actually like kind of exciting. Of course, we're all ERISA attorneys, right? So our standard for excitement's a little bit different than everybody else's, but this is really a big deal for those of you who are either kind of have been struggling with that audit requirement or find yourselves in a situation where, let's say you typically have about 75 participants and you've got a lot of part-time employees who have never been in your plan. Under these new rules, if they suddenly are now eligible to save into your plan, even if they don't, the old 5,500 rules would have pushed those into your account and potentially push you over the limit. The new rules will protect you from that. So I think there is a lot of practical takeaway from this, Chuck. And I would urge anybody who's kind of thinking about some of these strategic decisions, like Chuck, as you can tell, has kind of thought through some of the mechanics and the strategy around that. Give him a call, shoot him an email, and I think he can kind of talk you through how to handle some of that. So Chuck, thanks again for your perspective on that. And now, Mike, I don't know if you're going to be able to keep up with Chuck's positive tone as you talk about plan loans. I mean, I think we're swinging to more of a bugaboo here. And, plan loans are those kind of a necessary evil, apparently, for a lot of plans. And more than anything, what we want to be able to do is, number one, figure out how they can be done well and in an educated fashion and without operational failures. But then, number two, when there are failures, how do we fix them? And I think there are some real challenges there. So I think you're going to kind of talk us through here a little bit, just some general loan background provisions so everybody can kind of be aware of the context. And then you're going to talk through a little bit about how do you go about changing or how do you go about correcting those failures. And actually, there is a little bit of good news there, right? The government's actually made that easier in recent years than it used to be. But I'll turn it over to you and let you talk about plan loans.
Thanks, Matthew. So just some basic foundation here. Loans are not required in your 401k plan. It's a plan sponsor, plan design, culturally sort of driven choice. I'll tell you that most of my clients don't offer loans. They do offer hardship distributions. We can take that up on another call. If you do offer loans, there are caps as to how much can be taken. Effectively, it's $10,000 with a cap of $50,000 up to half of your account balance. There's a little bit of a wrinkle in there as to whether or not it's half of your account balance or 10,000, but if you've got questions about that, we can follow up. The interesting thing about 401k loans versus borrowing from another source, there's no underwriting. So if you've got credit issues, but you've got a decent 401k balance, that might be a source of funds. And I'll come back to the reasons why that might be a good idea for some people. The interesting thing about loans is, in terms of repayment, there's a pretty hard cap on that. And so you've got to repay the loan that you take out within 5 years, unless the home is used to pay for the primary residence of the participant. And that could be an immediate primary residence, or there's a little bit of leeway there, so within a reasonable period of time. Most plans that I'm aware of don't require spousal consent. That may be a requirement. But I think kind of the point that you're trying to get to here is loans tend to be problematic. And so just a couple of ways that, I've seen those things kind of go south. For whatever reason, it seems like it's pretty difficult to administer loans from the internal payroll function. So I've seen, we get loans set up, and for some reason, the payroll provider is not talking with the HR director, or it's not synced up with the 401k. Let's suppose, for instance, there's no 360 integration and somebody's got to enter that information in manually. I've seen a number of circumstances where the loan is taken out, the request is sort of processed, but for some reason, the repayment of the loans doesn't happen relative to the payroll provider. And so in that circumstance, we've got this loan that's sitting on the books. A participant took it out, they received the funds, they signed up to have the repayment taken from their paycheck, but it's not taken. And as you know, when that happens, you fall into a situation where you've got a deemed distribution, and you're going to have to make a correction. So that's one example. You can also see if you've got a record keeper, for instance, that maybe has a little bit more of an antiquated system, and it doesn't necessarily have the good coding sort of embedded in the system. You could have a situation where someone exceeds the maximum loan amount, right? We talked about the hard cap there, $50,000. So that's a circumstance that I've run into, although that's a little bit less common. So for whatever reason, loans tend to be less, they tend to be an administrative burden, and then they break. And so the question then becomes, how do we fix a loan when we find out that it's been broken? And as you've said, you've alluded to here in our talk today, and I did go back just so you get a smile. I listened to your Fiduciary 15 from February. So you talked about the expansion of EPCRs under Secure Act 2.0. So Secure Act 2.0, Section 305, and I love the language at the beginning of it. It says, because of the ever-growing complexity of retirement plan administration, we're going to expand the ability to engage in mistakes or fixing of mistakes through the process, the self-correction process. And as you've talked about in your Fiduciary 15s, and most folks know, there's three sort of ways to fix a mistake. One is the easiest way, which is a self-correction. The second is to file with the IRS, the voluntary correction program. And then if you have an unfortunate circumstance where you get an auditor at your doorstep and they start going through your plan, the final sort of formal process is the audit cap. So in this case, as you've said previously in Fiduciary 15s, I think Chuck alluded to it earlier, we want to try to stay in that self-correction program. And it used to be that the IRS sort of distinguished between inadvertent failures, or I'm sorry, significant failures and insignificant failures. If you had a significant failure, then you had a kind of a hard fix on how long you could take to fix the mistake. And so that's been sort of changed through Secure Act 2.0, Section 305. And as you covered last June in the Fiduciary 15, the notice 2023-43, we've got a new term, eligible inadvertent failures. And if you have one of those, then you've got a reasonable period of time to fix the mistake. So, I think I'm kind of running close on time here. What does that mean if we're going to fix under a self-correction program through the expanded provisions that we have through 2023-43? It means that you're going to need to look at the failure, you're going to have to identify it, figure out why it happened, make a good faith effort to fix it. We have to have sort of a, if you think in the old NCAA context, we have to have institutional control here. So we've got a compliance program that's designed to comply with the code. And then we're going to have to document the fix that we're going to make, determine how many folks are impacted, et cetera. So that is a good way to sort of take care of these situations where, as I talked about, you've got a loan set up and for some reason repayments aren't happening. If you get into a situation where the old rules apply, VCP must be used, that's going to occur if you've exceeded that maximum loan amount, or if you've exceeded the maximum repayment period. And so with respect to the maximum repayment period, that's that 5-year period that I talked about. One way to fix that may be to re-amortize the loan. Just make sure that you don't go past that 5-year period from when the loan was initially taken. So I think that kind of covers it, Matthew. I don't know if you want to add anything there, or the other attorneys want to talk about their best loan stories. I am aware of one circumstance where there was sort of an antiquated system, and a husband and wife took out loans for $100,000 each, and that's obviously way above the $50,000 cap. So you just have to be careful with it. You got to pay attention to it and make sure that you're working with your payroll provider and your 401k provider to make sure that things are sort of set up correctly.
You know, Mike, I think one of the things that's changed the most regarding plan loans since I began to practice law 2 decades ago now is that notion of re-amortization used to scare us. It used to freak us out. It used to be kind of a bad word to use. And now there seems to be, on the one hand, an increased acceptance of the ability to re-amortize the loans when there's some sort of operational failure. But you just hit on a really key point. I hope everybody heard that. The re-amortization is not extending the duration of the loan. It's merely taking the amount payable and re-amortizing it over that same period of time that was otherwise remaining. So that's kind of good news, bad news, right? You do indeed have a lot more flexibility to just kind of get things caught up and to get them caught up over the life of the loan. But this doesn't mean that we're going to like continuously be able to add years onto the back end of the term of the note. So I think hopefully everybody caught that. I think that's the most significant part of what you shared, Mike.
Thanks, Matthew.
Yeah, appreciate that. So so you've referenced already, you know, you and Chuck both referenced some of the changes from Secure 1.0 and 2.0. I think it's pretty common for people to say, wait a minute, okay, we're past the halfway point of this year, and we've got provisions either that are already effective, or we know some might become effective or available really soon, start of 2024. So what should we be doing right now? And what we wanted to produce for you here is kind of a roadmap or a game plan for you to utilize this quarter. So what should you be doing the rest of this month in August and September to kind of try to get ready for some of these potential changes? And we're really stuck still in a little bit of a state of limbo. If you've been on some of our other talks, you've heard us address that the expectation that the IRS is going to give us a grab bag of guidance here sometime in the next couple to few months. And that's going to fill in some holes and answer some questions, but we don't think that it's right for all of you to wait until that to go through some of this preliminary blocking and tackling you need to do to figure out what you may or may not do in 2024. So really, we think there are 4 key steps that you can see in front of you. Number 1, we want to ask your particular record keeper, will the big 3 be available in 2024? In other words, will you, as our record keeper, be supporting these 3 big kind of optional provisions that either already are technically available in the case of employer Roth employer contributions, or will you make available the opportunity for us to match student loan debt repayments, or for us to make available emergency savings accounts? Start by asking the record keeper, do we think these things will be available, rather than getting all the way down the road and finding one that you like, only to be disappointed with the fact that the build out, the technology that requires to get there is something that leads your record keeper to say, we're not going to quite be able to facilitate that next year. So that's the starting point, and you can work with your advisor to have that conversation. I know that, you know, Scott and Chuck and Mike and I have been working with record keepers, and we see answers all over the place. We see some of the leaders saying, you know what, the law's made it available, we're going to dive right in. Seen some that said, we're not going to be ready for any of that. And others that have split the difference. They've said, you know, we really want to be able to accommodate the matching of student loan debt repayments, but we're not as excited about the emergency savings account. So that's going to be more of a 2025 issue or later. So start there. Are the big 3 going to become available? And then secondly, start to plan a little bit for the common 2023 or 2024 provisions so that you have your ducks in a row on whether some of those provisions will apply. And you can see we've listed 3 of those here. One has really already kind of kicked in, and that's the extension of that required minimum distribution trigger. You know, many of you used to think of that as a 70.5 rule, and then Secure 1.0 moved it to the 72 rule, and now it's 73. We just need to know that that is now really in full swing, and when we get to next year, we'll be using the age 73 for about the next 8 to 9 years until that extends again to age 75. So that's probably the first of those 3 items. The second of those is to get ready to the extent you can for this requirement that catch-up contributions made by any of your employees who have wages in excess of $145,000 this year must be made as Roth contributions next year. So this is going to require a lot of coordination. Your record keeper, your TPA, your payroll department, your payroll provider. We got to figure out how that's going to work. And in fact, there are so many questions about how it's going to work. And there was a major drafting error in the law that Congress adopted that actually technically took catch-up contributions out of the law, which wasn't intended, that has led lobbying groups to go to Congress and say, hey, when you get in to fix that inadvertent removal of catch-up contributions altogether, why don't you go ahead and defer or delay the effectiveness of this requirement? Nobody's going to be ready. Please just push it off. We don't have an answer on that. I don't know when or if we'll get an answer on that, but you want to start thinking about how that might work, recognizing that there are a lot of gaps that still need to be filled. And then the next is just to think about your small account or your mandatory cash out limit that's in place. Most of you probably have a rule in your plan that says if somebody leaves and they have a vested account balance under $5,000, you can cash that out. The new law allows you to take that $5,000 limit and just increase it up to $7,000. You don't have to, but you can, and you want to be thinking about whether that's something that you want to do. So that's number 2. Step number 3, how are we going to make a record of what you decide to do when it comes to these optional provisions? It's really interesting. When a big law comes in like this, we could get really nervous right away because we think we've got to amend our plan to make sure everything's in place. But the law typically actually gives you a grace period to then eventually be able to adopt a retroactively effective amendment. And in this case, you actually have, for your calendar year plans, you actually have until the end of 2025. So there's not necessarily urgency around adopting the amendment. But if you don't adopt an amendment, how do you memorialize what you decided to do? If you change your cash out limit from 5,000 to 7,000, where do we write that down? If you decide that you want to match student loan debt repayments, how do we write that down? So we want to converse with your record keeper and say, hey, how are we going to do that? Do you think that we'll have an amendment? Do you think you'll give us like some sort of checklist and we fill it out and tell you what we want to do? We don't know the answer. It'll be really varied, but record keeper by record keeper. But you just want to start thinking about like, how will we memorialize what we do? And then the last part is for you to start thinking in advance about your participant communication strategy. You know, many of you know that when you make changes to a plan, you have a requirement to inform your participants by giving them a summary of material modifications. You have to tell them you made the change. But really, you have like a surprisingly long time to tell them about that after you adopt the amendment. But I would suggest that if you're doing these things to try to add additional bells and whistles and positive features to your plan, or you think your employees will make different decisions if they understand how your plan's working, you want to let them know in advance. Maybe you want to make a splash with some of this. Start thinking about what you want to do from an educational perspective. Why would we want to go through all the trouble of adding a matching contribution for student loan debt repayments if we didn't also want to inform your people about it and make them like your company more because you're doing something extra to help them? So how do we make that splash? So that's our strategy map. You know, I hope you'll tune in as we have our webinars throughout the rest of the year, because as the IRS, the Department of Labor, continue to give us guidance, we'll be sure that we keep you up to date on that. But we want to shift for a moment now. I want to talk a little bit about litigation. And we could do, you know, 2, 3, 4, 8-hour presentations on litigation. We're going to try to be pretty quick and work through a lot of topics here. But here's the general essence. I think it's very common for people to say, why am I paying attention to retirement plan litigation? Either I feel like we're doing okay, or I feel like we're small, so nobody's really going to come after us. And there's really some important things for you to know about, not just because you may or could get sued, but frankly, if you want to be a good fiduciary, it's really important to know what typically indicates a bad fiduciary overseeing a plan. And so what I would suggest to you right up front is let's just look at a little bit of data. The number of lawsuits continues to ramp up. We saw a little bit of an increase several years ago. It dropped off a little bit. Then we hit the pandemic and things really took off. And those lawsuits aren't just targeting plans in one industry or plans of one size, but as you can see, they're hitting, private companies, nonprofits, financial institutions, public companies. And as you can see on the left here, they're also starting to hit plans that are of all sizes, and they're coming down market. And one of the reasons they're coming down market is because the settlement activity on the right means more settlement dollars come in to those law firms, which gives them more money to be able to go out and seek more claims. And there's a snowball effect that when a plaintiff's firm wins, they're able to pursue an exponentially increasing number of additional cases. So we want to be very mindful of that when it comes to retirement plans. And we also want to highlight for you 4 specific cases from this year that we think are noteworthy and might give you a sense for where things are going. The first of those is Hughes versus Northwestern. You've probably heard us talk about Hughes versus Northwestern for a couple of years. Well, in January of 2022, the United States Supreme Court issued its opinion in Hughes versus Northwestern. And what it really said in that situation was the lower courts got it wrong. They dismissed this case without applying the right standard. The lower court should go back and look at whether this was a well-pled case and consider whether it should survive this motion to dismiss. So it goes back down to the 7th Circuit. And in March, the 7th Circuit, which initially had said, yeah, we agree with the defendants on this one, we're going to throw this case out. In March, the 7th Circuit said, ooh, now that we apply what the Supreme Court has reminded us we need to do, we are not going to grant the motion to dismiss. This lawsuit is going to continue. And that is what we expect will continue to occur. I just showed you that the number of settlements had already started to increase. That number is going to continue to exponentially increase because of more and more suits getting through a motion to dismiss, which gets you into discovery, which gives the plaintiff's firms more leverage to push towards settlements. So you can see, for example, the second case here, this Davis versus Magna case, the court denied the motion to dismiss, said, no, we're going to move on into discovery. And the reason is, although if there isn't a deliberative process in place, that's probably enough to show that there is imprudence. But this is interesting. Even though the defendant said, but we had a prudent process, the court said, well, just because you had one doesn't mean there's actually prudence in place. So we're going to let this get into discovery so that we can look at whether your process was actually any good. And then when you look at the Miller versus Pfizer case and the Zimmerman versus the Cedars-Sinai cases here, those get at a slightly different issue. So after the the Hughes versus Northwestern University case at the Supreme Court level, after that opinion was handed out, a lot of these firms started filing a lot of lawsuits. And what they basically said is they walked in and they said, not only were like the funds too expensive, but the record keeping expenses, they're just too high. And the court said, it's not enough just to say something is too high. You have to really kind of show that it's not valuable. In other words, you don't have to go cheap. You absolutely don't have to go cheap, but they need to be reasonable. And in order to determine what's reasonable, we need to know the value. So what's happened here in these cases is the plaintiffs' firms have become smarter about that. And in the Miller case and the Zimmerman case, what they walked in is they said, not only were the services too expensive, but these are essentially commodities. These are fungible services. There was no additional value provided by this record keeper that was charging twice as much the market value. And in both of those cases, that's the approach it took. And in fact, in the second one, really good argument here. And I think more and more plan sponsors and advisors are going to think about whether an asset-based fee makes sense for record keeping purposes. And the argument in this case was, hey, the plan was $100 million. And then you had the same number of participants and it was $200 million. You doubled your revenue, record keeper, even though your workload didn't change. And you also didn't pick up additional liability. So the record keeper is not a fiduciary. So as the assets grew, the record keeper's liability didn't grow. So why did their revenue double? And I think that's a pretty interesting argument. We'll continue to pay attention to that. We're not really at a point, I think probably makes Chuck and Scott, Mike all uneasy with the idea that we'd say that fees have to be asset-based or they have to be flat and that there's only one right answer. There isn't one right answer. But that standard of reasonableness is going to kind of prevail through all of those conversations. Okay, so that's really the end of kind of our first 5 sessions or 5 sections. The way that we want to wrap up here, I want to go around the horn, and this is where everybody gets to test our abilities to be brief with our comments. Hint, hint. So I want to know really what's on the minds of Scott and Chuck and Mike. And I asked them a little bit. I gave them tons of advance notice. I asked them almost a couple hours ago, what would you like to be able to talk about at the end? What's something that you think people need to pay attention to? And so I think let's start with you, Chuck. Talk about these cash alternatives issues that should be on fiduciaries' minds the rest of the year.
Yeah, this is just a reminder for plan sponsors to be looking at their cash alternatives, whether that's money market funds or stable value funds. For the last 10 years, there hasn't really been a reason to look at them. Money markets were paying nothing, and stable value funds were paying 2 to 3%, but the dynamics have changed with the high interest rates. Your money market fund has gone up, but your stable value fund perhaps isn't paying as high as it once was. Participants are asking, hey, I can go out and buy a CD at 4.5%, 5%. Why is our fixed account or our stable value fund not paying the same amount? Well, we'd love to have that discussion. So just something to bring up in your committee meetings and flush out what's best for your plan and how you communicate that to your participants.
Great. Thanks, Chuck. Scott Liggett, I know you're thinking a lot about increased debt load. A lot of participants are carrying. Got you on mute, Scott.
We had a bet earlier who would do that, and I lost. As people here at QPA know, I subscribe to a lot of periodicals. I track a lot of information, and I think the growing amount of consumer revolving debt is growing at a pretty accelerated pace. And when you layer on top of that, the inflationary pressures that are going on, higher costs of borrowing, the restart of, depending on your demographics, the restart of student loan repayments. And I think you'll see for QPA clients, you'll be seeing this quarter a lot of data about surveys that our Financial Fitness for Life people have done. You'll see a lot of really important data in there about the need, I think, really to shift from, wouldn't financial wellness programs be a nice thing to offer, or maybe a nice complement? I think we're going to have to shift the thinking and shift the focus from a may want to do that to must do that, and I think that's going to become more and more part of the dialogue as we develop and go along, and the current economic times.
Great. And then Mike, I know you're thinking a lot about other benefit programs that plan sponsors are starting to explore.
Yeah, Matthew, we talked about that. With a lot of my clients, there's still a battle for talent, particularly in the executive level. And when you're trying to bring on someone that's going to be a high earner, sometimes the 401k chassis really just isn't enough to get that individual to where they need to be and preserve their lifestyle in retirement. And so I'm talking with a number of clients about cash balance plans. Obviously, the attorneys here are familiar with those. They've been around for a period of time, and they're often used in the context of a changing control of the business, but also non-qualified deferred comp. As you know, you've got to be somewhat careful with those plans in terms of making them widely available, but there's also some things that you can do with respect to the definition and showing how a particular class of employee is essential to a business. And you and I have had some conversations about how to do that. So those are the things that I'm talking about right now.
Great. And Mike, I think that tees up the thing on my mind. Obviously, like the litigation trend and the focus on fees means people need to and want to benchmark their plans for traditional purposes, fees and the value that comes with those fees. But I think what a lot of people will spend the rest of the year doing is trying to benchmark the overall value and services attached to their plan versus their competitors. Is their plan really built out? Is it designed in the right way? Do you have the right investment options available to your people, the right services available to them? Are you looking out for your people's financial wellness? And if you're not, then you're falling behind your competitors in this race for talent. And if you are you doing a good enough job of talking about it and advertising that? That's where I think we'll be the rest of the year. And I think the last thing we'd share with all of you is, we urge you to challenge yourselves, be a good fiduciary. Really dedicate yourself to being a good fiduciary. You are a steward of your employees' futures. You're a caretaker of their ability to someday not only retire, but hopefully retire comfortably, to live a dignified retirement. And there's a quote from this Eighth Circuit case from a couple of years ago that I really appreciate, where the court said, you know, a failure of effort or competence is enough to state a claim for breach of the duty of prudence. What does that really mean? Well, it means if it looks like you're not trying, or you just aren't any good at it, then you might be liable for a duty of prudence. But more than anything, you might be responsible for your people not getting to where they need to be in order to retire well. And more than anything, if you need a cautionary tale, look no further than this case of a couple of years ago, where the court went after some specific fiduciaries by name in the opinion, read them the Riot Act. And you know what's fascinating about this case? In this case, there was not liability. This was not about liability. The court actually said there is no liability for the fiduciaries. However, we think they were so bad that we're going to pick on them by name and talk about their testimony being concerning, displaying a surprising lack of in-depth knowledge concerning the financial aspects of managing a multi-billion-dollar plan, being unfamiliar, not having time to serve on a committee. These people never set out to embrace not only the responsibility of being a fiduciary, but the opportunity. Be a good fiduciary. Commit yourself to doing that. Commit yourselves to being educated. If we can help you with anything, please reach out. We'd love to have the conversation. Once again, thank you for joining us today. Thank you, Chuck, Mike, and Scott. Certainly appreciate the opportunity to work with all of you, to learn from you, and hope that everybody has a wonderful rest of the afternoon. Thank you.
Thanks, Matthew.
Thanks.